hear us, Mr. Laprevost?
Yes, can you hear me?
Yeah, perfect. So you are connected and we will start shortly. Thanks.
All right, thank you.
Will this do? Great. So now we will compete with the coffee you just took, as we are planning a very engaging session to have. So my name is Astrid Bahramian, and I will be moderating this session. I'm the assistant of the chairman of the Competition and Consumer Protection Commission of the Republic of Armenia. Simultaneously, I am a researcher at the Environmental Studies Center of the American University of Armenia. And the majority of the professional trajectory of mine was in the legal department of the Commission. And so I switched from the legal battles to policy implementation mostly. And today's topic sits exactly in that intersection because when we talk about competition and sustainability, the first question that arises is how do we save the planet without actually accidentally violating some competition rules? And that is not always a simple task. And here always competition advocacy comes for a help because competition advocacy explains some difficult, bizarre competition rules to the policymakers, to businesses, to consumers, to all the stakeholders, and helps to understand where is the line. Is it actually a sustainability initiative, or this is an anti-competitive practice but with a good marketing? So to tackle with these issues, I have a fantastic team of panelists, exceptional representatives of private sector and public sector, and let me briefly introduce them. First, we have Ms. Marjorie Holmes, partner at Reed Smith in the United Kingdom. She is also appointed as a non-governmental advisor to the UK Competition and Markets Authority. Ms. Holmes is a highly experienced competition lawyer who has been advising clients on EU and UK competition law for many years across sectors ranging from aviation and energy to finance and life sciences. Importantly, for today's discussion, she has also extensive experience advising trade associations and companies on sustainability collaborations, which means she has probably very frequently received questions like, can we do this in a sustainable way, but refrain from competition authorities, refrain from fines? We are very happy to have you, Ms. Holmes. Our second panelist is Ms. Sonia Moura, Senior Legal Officer at the Portuguese Competition Authority, as you might remember from the recent plenary session. Ms. Moura has been working at the authority since 2004, which means she has seen competition policy evolve many phases. She currently works in the Studies and Market Monitoring Bureau, and as I remember correctly, she's the only lawyer there. Yeah. Before joining, I'm an active listener. Yeah. Before joining the authority, she worked also in a private sector. So it is fair to say that she brings a wealth of institutional memory to our panel and practical insight to our discussion. And of course, our last panelist, who couldn't unfortunately join us offline, is Mr. Francois Charles Laprevost, but still we are very happy to have him online. He's a partner at Cleary Gottlieb Steen and Hamilton Law Firm. Mr. Laprevost focuses on European competition and international trade law and has advised clients in numerous cases before the European Commission, the European Court in Luxembourg, and French Competition Authority. Before joining the law firm, In 2007, he served as an advisor to the French Minister for European Affairs and previously worked at the European Commission Directorate General for Trade and the Inspection Generale des Finances. So he has the really extensive background, both in the policy development and the private sector. So, Mr. Laprevot, we are very happy to have you with us, and the distance does not have any obstacles. And let's begin with this, our discussion, which will actually set a stage for our whole session. How do you see the intersection between competition policy, competition advocacy, and sustainability? This is a question that has become very mainstream in recent years, and I am very curious to hear your perspectives. And Ms. Holmes, I will invite you to go first.
First of all, thank you for having me. I'm delighted to be here in Armenia. In the UK, just a bit of background, we adopted a self-assessment procedure back in about 2003, along with the rest of the European Union, as we were part of the Union at the time. So under that procedure, the self-assessment procedure, if you have a sustainable agreement that your lawyer can assess as positively pro-competitive, you can, of course, have it. You can have a sustainability agreement. But in 2022, the CMA, the UK Marketing Authority, were being told by numerous sectors that they were hesitant to have sustainability, including climate change agreements, because of their fear of competition law. And I can give you an example of that, classic example. The supermarkets were being encouraged to stop providing plastic bags to customers for nothing. But the supermarkets, none of the supermarkets wanted to be the first mover to require a payment of the plastic bag. And they feared agreeing to charge for plastic bags or not provide them because of competition law. So a regulation was required to make that happen, and it's still a regulation. But the UK carried out a consultation with different sectors and said, show us your evidence that you're genuinely not doing sustainability agreements because of fear of competition law. And as a result of that consultation, they came out with the Green Agreement Guidance. And of course, guidance is not new legislation, it's just explaining the old legislation. And under the Green Agreement Guidance, they allow individual applications to the CMA for them to discuss whether your agreement fits within what the CMA would regard as a positive light. So we do have this procedure now for informal guidance, and there has been 4 cases so far, which I'll tell you about later, where the CMA have been approached. And to answer your specific question, one of the things that I find from the guidance that is made very clear is that in the past you've thought about the competition authorities looking after the particular consumer who bought a product. But what this guidance shows you is you don't only consider the particular consumer, you can consider the wider public when it comes to sustainability and in particular climate change.
Thank you very much for your insight. It's very actually interesting that competition law has to be very flexible in order to encourage businesses to do the first steps, which they were afraid to do before. Thank you, and now we go to hear the Portuguese perspective.
So thank you so much for the invitation and also the opportunity here to share the views of the Competition Authority on the intersection between sustainability and competition law. So as you said, I was fortunate enough to work for the last 8-9 years in let's say, policy department, but also market studies department. So I was one of the persons working on best practices guide that the ADC has adopted in 2024. on sustainability. Why? Because the authority wanted to contribute, picking up one of its toolbox mechanisms to, first of all, to say that competition law can go hand to hand with sustainability. Competition law can foster sustainability. Competition law can help companies, associations of companies, of undertakings, to go further, especially to, let's say, to erase this first mover disadvantage, as the example that you have brought with the plastic bags illustration from the UK. So sometimes companies, they are concerned to be the first one to give this path, normally because when some sustainability initiatives are adopted, that means that either you lose, either prices increase, so you have to pay more for that product that is more sustainable, more green, or you lose diversity. For example, washing machines. So some washing machines are A+, and the other ones are DF. That means that they spend more energy, they spend more water. They are cheaper, but in the end, within a range of 5 to 6 years, you will pay more in electricity and water, and you can damage society by wasting more energy, wasting more resources to produce energy, wasting more water. So between this dilemma, the role of competition is really to say, especially competition authorities are here to pick up several of these policy boxes. I've just illustrated one of the policy boxes. We adopted these best practices guidelines that illustrates clearly where to draw the line for companies to engage in these cooperation agreements, whether they are good for competition, whether they are good for economy and society as its whole, or where to draw the line, and please do not disguise these cartel agreements with, a green cover. So the second, and I will talk more about the guidelines later on. So another toolbox that we use to promote sustainability and, let's say, green economy is also market studies. So we have addressed the new issues with the green society, that is electric mobility recharging. And Portugal is one of the countries in EU that has more high rate of buying new electric cars. So we are replacing the petroleum fuel used in our cars we are moving to electric cars, but we have encountered barriers to enter, and barriers to consumers in recharging the electric recharging for these new vehicles. So we have also addressed recommendations, I will later on explain them, to municipalities and to the government. And the other, let's say, two mechanisms from the toolbox that we can use to enlighten how these two areas interact is to advocate for pro-competitive public policies. And I would say that may be the first mechanism of our advocacy toolbox to use. Why? Because if we have good legislation, and we do know that public decision maker needs to combine environment, economy, and then competition. And competition is just one aspect of the public policy. So first, we need to explain the benefits of, and to bring sometimes alternatives. It's not just say it creates barriers. You need to convince the public decision maker to do better regulation. So if everything starts with a good regulation, then we can have a path through. And I will stay for here and then gladly to contribute.
Yeah, thank you very much. Actually, an important point that competition enforcers should sometimes fit in a big picture of policy development and address issues that are important for this whole society as a whole and the business environment. And Mr. Laprevost, the stage is yours now. Please.
No, thank you very much. And I have to say I concur with a lot that has been said so far. The tension for me is not so much about, let's say, competition versus sustainability, in the sense that, as was said a minute ago, competition is also part of, obviously, a broader set of public policy objectives. What you can have, however, is a debate on which instrument does what. Essentially, if you look at regulation, which was mentioned, it's there essentially to correct externalities, to set minimum standards. Competition law is primarily obviously aimed at protecting rivalry and guarding against private coordination that basically allows parties to exonerate themselves from market discipline. Now, if you look at the EU, which is what I talk about mostly, I would say you have both a legal perspective and an economic perspective that really commands integrating sustainability into competition policy. The legal perspective is that if you look, for instance, at the merger regulation and generally at antitrust, the Commission must place its appraisal within the general framework of the fundamental objectives of the EU, and sustainability happens to be under the treaties one such fundamental objective. It's in the TEU and the in the TFEU. And then you have the economic perspective, which revolves a lot around the notions of externalities and efficiencies. And for instance, you can see this including in the debate on the new merger guidelines. But if you mentioned earlier, the objective of saving the planet. If you just take climate change as an event that will probably basically be triggered through several thresholds, even some of which have already happened, the economic consequences which are calculated can be absolutely enormous. Some economic studies have calculated that for instance, British Institute of Actuaries would expect, if really all the scenarios of climate change materialize, a loss of GDP between 25 and 50% within our lifetimes. So that is not just a pure sustainability issue; it's also an economic issue. And just one last point: to solve these kind of collective action problems, you have basically three possible classical ways. One is regulation, the other is taxation, and the last one is cooperation. And you can obviously think of regulation or taxation, but when you are talking about a worldwide event like climate change, basically to be adequate, these kind of actions need to be both effective and take place worldwide. And we know that we are very far from there. I mean, if you look at what basically the true cost of carbon is compared to what, for instance, is the emissions price in the EU, and the EU is one of the most advanced systems that has tried to establish a price for carbon, which leaves cooperation. And obviously, cooperation between competitors in some cases may be a solution, but is not agreed to in all parts of the world. Think of the US. Another area for cooperation is obviously mergers, which again might help in some very specific settings through efficiencies, economics of scales, or innovation, and all these can have an impact on sustainability.
Great, thank you very much, Mr. Laprevot. So what I understood that we have a consensus that competition law and sustainability rarely stay at one legal framework, and it's actually a very multidimensional thing. And thank you very much, all of the three panelists, for the perspectives. Already from these reflections, we can see that the conversations around the sustainability and competition policy are becoming increasingly nuanced. And now we would like to move from the bigger picture to the practical level, where the question will be what are the most effective tools used to provide clarity and encourage legitimate sustainability initiatives while still preserving competition. because of course many businesses want to be sustainable, but the question arises, what are we allowed to do, how we are allowed to do it, etc. So again, Ms. Holmes, starting from you.
Thank you. I should have said that I've got some background material here. If anybody wants to, I'm going to talk about a few cases, but if you want the references and the links, there's some background material there that you can collect. So I would like to talk about the informal letters, the guidance letters that I mentioned earlier. We have 4 cases in the last 3 years. So this procedure is being used in the UK. And my observation on these letters is that the CMA, to me, are being quite generous in the way they're dealing with these. As I mentioned earlier, you have to have carried out a self-assessment before you approach the authorities to talk to them on an informal basis. But in one of the cases, one of those 4 cases I'm going to mention, it hadn't been done properly. And the authorities said, you should have done it, we expect you to do it, and if you had done it, we'd expect you to find the following. So I find that's a very generous approach, and that's the UK authorities trying to encourage people to use informal letters. The first one that we had was to do with fair trade, and it involved bananas, coffee, cocoa, and it involved farmers and buyers agreeing to a minimum price to be paid to the farmers, so a minimum price. The self-assessment set out why it was needed in order to encourage the farmers to put the right investment to improve the environment, and that was allowed. So you can see why that might be a competition issue, that they'd want to check minimum price. There was another one involving the UK supermarkets, where our big supermarkets were allowed to agree jointly to require their suppliers to at least try for net zero and follow science-based targets. So it was a general agreement to require a scientific approach to net zero. Then there was another one to do with the building trade, where the building trade were allowed to agree to a single platform for an advisor on how you set up compliance with ESG. And that was on the basis that one needed to be set up, but it didn't need to be the only one, that others would come later, but it would speed up the compliance with ESG. So that was the third one that was allowed. And then the most recent one involved 350 farmers, and it didn't just relate to the UK, it related to the UK, Italy, Poland and Hungary. And it was 350 farmers and producers, and that one involved an investment of about 20 million from both the buyers and the farmers. I mean, some of the arguments was that when you've got 350 farmers, individually they couldn't do this agreement, so it wasn't anti-competitive at all. But of course you had the producers, some of which, the buyers, some of which were quite big. And there they wanted to have joint purchase and joint selling. And they were allowed to do that in return for showing that they put investment into improving the environment in terms of stopping flooding and also building trees. So we've got 4 cases of informal guidance given by the UK competition authorities. And when they do this guidance, they make it clear it's light touch. It's based on the assessment and the facts on the assessment and what's in the public domain. So, but they conclude by saying if the facts are correct, if what we've found is correct, then our intention is not to bring an action, not to investigate you and not to fine you. And I would say that procedure is going to be used quite a lot given the CMA's approach to encourage it.
Yeah, actually a very generous approach from the CMA, agree, especially concerns would arise concerning the resources, I guess. But that's a thing that deserves because sustainability requires joint efforts, long-term investments, as you mentioned. So before going into sustainability agreements, the businesses should really be sure that it would not bring like bad consequences for them. Yeah, thank you. And Ms. Mora, could you please provide your perspective?
Yes, well, as my initiate words have indicated, so I can confirm that we have several effective tools to provide clarity, to encourage legitimate sustainability. But as I already said, achieving this challenge successfully involves this multitude of initiatives, and certainly, or most probably, to give informal letters or comfort letters will not be the most appropriate toolbox to address these challenges. Exactly, and we can later on discuss pros and cons of informal guidance letters. There are other mechanisms, and those are the ones that the ADC, the Portuguese Competition Authority, has invested. So first of all, just to give you some examples, we have advocated for pro-competitive public policies, and the ADC issued 2 opinions and addressed it to the government regarding proposals of the government for strategic plans regarding the environment, and these strategic plans were regarding the non-urban waste and circular economy. So the ADC alerted the government that the strategic plans, they encourage competitors and firms to collaborate. And this collaboration was to amount to exchange information for the collaboration to pursue. So what we have alerted was that although in some areas to foster innovation, to foster a green energy sector, for example, to foster green in some areas, not in all areas undertakings competitors need to exchange information, and if they need to exchange information to pursue those collaborations because they aim to achieve a more important goal, they should limit the exchange of those informations to the standard that we all know, not strategic, not confidential, not about selling prices, not about historic price, even historic, depending on the use of the data. So we have alerted and we publish our opinions addressed to the public maker, highlighting some of the main principles contained also in the guidelines for horizontal agreements from the European Commission, which we also use at the ADC. So actually, so we can use also this policy tool mechanism, which is addressing better design policies, and especially policies that do not even unintendedly promote exchanges of confidential information that may hurt competition in the end. And the other toolbox, as I mentioned, was the adoption of best practices guide. So the ADC, of course, that reflected upon whether or not to have informal guidance procedure, as other NCAs have adopted, as CMA, as French Competition Authority, as Dutch Competition Authority, as German Competition Authority. I would say the most strong NCAs that have adopted informal decisions and have published informal decisions. So, of course, that authorities need to ask why having informal guidance procedures just for sustainability initiatives and not for other ones. Of course, that we can have positive arguments, that is a new and innovative market trend, but there are also new and innovative market trends as in labor markets, another topic, as in generative AI. So, I mean, why not having comfort letters for all agreements? So I do think that there are pros and cons of these approaches. I think that it's very important that the procedure is very clear and brings security, legal certainty and security for companies. And also for authorities, that there is always a disclaimer in procedures from these authorities saying that all information gathered should first of all have a self-assessment by the companies, because authorities are not engaging in pursuing market investigations as if it was a market investigation, not going to do dawn raids, for example, to gather information, not going to make extensive RFIs, requests for information to companies. So departing from that gathering of information, of course, then you would have to have dedicated human resources inside an authority dedicated to analyze these agreements, to give these comfort letters and legal certainty. So the ADC has decided not to have this formal procedure. Of course, that we are always open to listen to all stakeholders that would like to come to us, but we did not have any request for appreciation, for example, a whistleblower case regarding sustainability initiatives. So the best practices guide is a very good toolbox. Why? Because inspired and using the guidelines of the European Commission on horizontal agreements, and especially the Chapter 9 on sustainability issue, which is very informative. We have gathered some of the main legal frames. That means that agreements that can go ahead, for example, databases of suppliers that use child labor in their productions, etc., etc. So the agreements that can go ahead, the standards that do fulfill conditions to also go ahead, and areas that at EU law, even where an agreement may be illicit because it has an impact in one of the parameters of competition, being price, quality, innovation, choice, it still can be justified. And this is very clear in the guidelines. And it can still be justified, 101.3 of the treaty. That means what? And that means that, and I will just highlight one of the 4 cumulative conditions. The undertakings, they must justify whether there is a fair share that from the benefits that is transmitted to the consumers, so as to, and this is the most important, so as to bring a neutral effect. That means that consumers that were hurt do acquire these benefits that neutralize their harm. And I would say this is a very difficult area for economists and lawyers. Also, the European Commission has acknowledged that regarding methodology to quantify collective benefits, for example, that accrue from the implementation of these agreements are hard. And with the case by case and the experience of the cases, then we all competition authorities will have more experience dealing with cases. So I can develop these kind of topics. They are more pro and con, but just to enlighten that even when a competition authority wants to bring clarity for the companies, needs to establish and needs to alert of the risks that certain corporations, they may hurt competition and may hurt consumers instead of bringing good to society and helping shaping, achieving these climate objectives. Thank you.
Ms. Mora, thank you for an extensive answer. I especially wanted to reflect on the first aspect of your speech when you talked about the interventions to the government strategy plans, because I believe that it's a really effective tool to prevent possible anti-competitive conduct when you communicate with the policy developers, because they develop policies that are like competitively neutral, let's say, and will not bring any harms to the competition environment as a whole. Yeah, thank you. And Mr. Laprevot?
Yes, thank you. To answer your question, which are the most effective tools that you can use if you look at the practice in EU and the European Commission, I think you can clearly see a toolkit that involves a little bit of everything that was discussed until now. I mean by that, first, obviously, guidelines. So I would say soft law, which is more more or less soft, can be a bit harder if you can invoke it in particular in front of a court. So guidelines, you had obviously the horizontal guidelines of 2023, which did, as was mentioned before, include a chapter on sustainability agreements, in particular standardization agreements, which are the most common form probably of sustainability agreements. You can think also of the upcoming revised merger guidelines, which will likely include elements on sustainability, and in particular probably under the angle of out-of-market efficiencies. So that's a first element, which is guidelines, soft law, which allow essentially players to do their own self-assessment and provide, sometimes this is the case of the horizontal guidelines, a set of criteria to determine what could be safe harbors. A second, still very important source is obviously enforcement, because you have, and decisional practice generally, because you still have a number of agreements, a number of practices that the competition authorities are going to consider are unlawful and toxic agreements for competition. A good example, obviously, is the AdBlue cartel decision in 2021, where basically the Commission considered that the so-called cooperation between the players actually hampered efforts to be more innovative and to reduce emissions even further. So that's also a very important source of information, including for practitioners, because it really gives you a good set of examples of what are, according to competition authorities, clear no-nos. And then you have what was also discussed, what is also now being tried in the UK, as was mentioned, or in the EU, which is informal guidance in cases that raise in particular new issues. And as you know, the European Commission in 2022 adopted a revised informal guidance notice. The Commission had not practically provided comfort letters or informal guidance for practically 20 years, and decided to relax somehow the criteria for providing this type of guidance. And in particular, the idea was no longer necessarily to consider that you had to have a total lack of clarity in order to provide on a specific legal issue in order to provide guidance, but that guidance could be provided in the absence of sufficient clarity, could be also provided in, by taking into account the Commission's priorities or the Union's interest, which may relate to sustainability, but not only. So this is not only directed at sustainability agreements, and then a number of procedural changes to make sure that the Commission would deliver this kind of guidance faster. And actually, you had an application of this revised guidance in 2024 with an interesting guidance letter related to a pretty, I would say, classical case of joint procurement. It was procurement by ports of some electric equipment. The number of equipment that are used in ports are actually diesel powered, so pretty polluting. You have now new kinds of equipments like straddlers, for instance, that can be powered electrically by electricity, but basically you need a certain minimal size or scale in order to procure these on a grand scale. And so a number of ports authorities decided to join together to procure these equipments and provide the suppliers some visibility about the volume of the market that they could hope to address, and therefore provide them with additional incentives to innovate and to invest into this new kind of equipment. And the safeguards that the Commission made public on this agreement in its guidance letter are pretty, I would say, classical again. the possibility for each port operator to continue to purchase independently from the joint agreement, a cap on the total volume that can be jointly procured, and obviously limitations to information exchange so that you exchange information only on what is strictly limited necessary for the agreement. So you see that through this kind of informal guidance, you can have some form of transparency. Obviously, as was said before, you never have total legal certainty. This kind of guidance letter does not prejudge what in particular the Court of Justice would say. This kind of letter can become inoperative if the factual premises change, and actually is typically limited in time, but you still have a form of effect, and you see that the Commission is looking both at the effect on sustainability and also on competition, in the sense that these safeguards clearly basically reflect also the need to maintain some competition for the purchasing of that kind of equipment.
Thank you very much, Mr. Laprevaux. Especially, I like the message of combining other priorities with the sustainability and not viewing sustainability as a separate island. This can be a good trick actually for the agencies, I guess. And thank you, very insightful answer. And I believe that although these advocacy tools, of course, shed some light in the difficult competition regulations and sustainability issues, but of course there could be some shortcomings and disadvantages of these advocacy measures taken by the authorities. And I would like to ask our panelists, what are the main risks and drawbacks of these advocacy approaches, and what especially the competition authorities should be mindful about? Ms. Holmes?
Thank you. So I think the main possible drawback is, and I think it's already been mentioned by a couple of the speakers, is there can be using sustainability as a cover for actual cartel activity. And certainly in the UK, we've had some misrepresentation of investments, greenwashing in the financial sector. And we've also had a case where vehicle recycling, there was some anti-competitive activity disguised under the sustainability barrier. So I think that's the main thing, is using sustainability to disguise some properly anti-competitive behaviour. I think the other area that's difficult as well is how do you put a value on the sustainability? I mean, I think we've argued over many years that when you've got scale, you get less pollution. But in the past, that was made very general, and it was like a tick box exercise. But now you've got to actually work out how do you actually properly value it in order for the authorities to then can make a decision on whether it's justified or not.
Yeah, thank you very much, Ms. Holmes. Ms. Mora?
I would say, and I would reinforce something that my colleague of panel have already said, is that informal guidance, it has positive aspects. That means that once the undertakings have carried out self-assessment, once they have carefully analyzed the conditions of their agreement, and once they cannot go ahead to eliminate first mover disadvantage, and once they have tried, for example, that their agreement is indispensable because they have, for example, tried to make a marketing strategy to convince consumers to acquire more sustainable goods. For example, the case of the turkeys. And still the consumers are not convinced, and the only way to go ahead is with an agreement. Of course, it is more clear that an authority with expertise, a competition authority with expertise, has the opportunity to advise and to revise and to give a comfort letter. On the other way, and the authority, Portuguese Competition Authority, has not a procedure to give informal guidance. Of course, that it has its pros, its cons. That means that you would have to spend resources that you do not have, and you do have to manage other priority sectors. As I said, why sustainability, why green sector instead of other areas of the economy? And especially because giving an informal guidance might, in the end, be not, let's say, completely justified. Why? Because an authority has not the time or the resources to make a market investigation, to make, for example, to analyze whether to make a consumer survey, for example, as in the case of the washing machines, whether or not consumers would be willing to change for other machines that are more expensive, but that would use less water. So I would say there are draws and backs. I think that the European Commission has only issued, I think, its first informal guidance letter after the amendment of its communication from 2022. And this explains, I do think that undertakings are still worried about bringing facts for a competition authority. And I think that's the main reason why the European Commission that has this formal procedure, but for the whole spectrum of sectors and not just for sustainability, has not yet received. And I do think it's fair to say that it is normal, and I do think that the experience in more cases will bring clarity, but also allied with more neutral legislation that even unattendedly brings these or may bring competition issues. But I would like to highlight another, let's say, aspect that is the aspect that, from a legal point of view, the possibility under Article 101.3 that all NCAs use the same article or the equivalent of that article. That means that even if an agreement may hurt one of the parameters of competition, being products more expensive, products with less innovation, products with less quality, less variety, still they may be exempted. But let's say the dissemination on how to calculate the benefits that accrue from society for the consumers, especially in related markets, I do think it's a topic that could benefit for a further explanation from a capacity building perspective. That means that it is not very easy to explain, and I do think that's very good that there are guidelines, that we have cases in the guidelines of the European Commission from 2023. The same cases there are in the best practices guide of the ADC, to bring these clarities about the no-nos and the yes-yes. And just to highlight my points, I would bring you two illustrative cases that we have in the best practices guide, and they are inspired also by the horizontal guidelines agreements from the European Commission from 2023. So one of the aspects that companies need to prove is that if the agreements restrict competition, they can still demonstrate efficiency. That means that they need to prove the pass-on efficiencies on consumers. So regarding the standard on they can justify the agreements showing that there are collective benefits that accrue for the affected consumers. And the two examples are, and this is always a challenge for the audience that may not be expert in these matters. So how would you consider an agreement, companies that come and say, well, you know, I justify these benefits because the measures I'm adopting, they benefit better clean air. So better clean air justifies the agreement that we undertakings are engaging. And the other undertakings have another agreement, and they say, well, you know, our agreement contributes to a better water. So you have water and air. These are both collective benefits that accrue not only for the consumers that may be hurt, but also for other consumers. So I'm going to give you the answer. So on the clean air, this is an illustrative case that consumers of more expensive but less polluting fuels are citizens who benefit from cleaner air. So you are using electric vehicles, for example, and you are making an agreement that has some characteristics. I'm not going to talk about the AdBlue case because the AdBlue case, in the end, the European Commission, of course, and well done, condemned that disguised cartel agreement. But using less polluting fuels, they contribute to a cleaner air. And the cleaner air we all breathe, and the consumers that may have to pay more money for buying a certain fuels that have additives that turn them less polluting, they benefit in the end for the same kind of consumers because we all breathe the same air. As long as the collective benefits allegedly that benefit societies regarding the water, they cannot be considered, and I explain why. So consumers of more expensive sustainable cotton, and I will terminate. Thank you so much. So consumers of more expensive sustainable cotton, so we have Eco t-shirt. It was grown with less fertilizer, less water, but the benefits on that water is locally considered. So the water does not flow away into the ocean. So it's locally, it locally protects that water, but the clothes, they are sold all over the world. So these are the specificities when experts or at NCAs need to deal when companies come to us and would ask for a comfort letter to give in 1 month or 2 months. These are the kind of cases that experience is good. It's good to have them in guidelines. It's good to have them in best practices. But we still need to mature the topics, and this is an illustrative aspect of pros and cons and how difficult the topics are. And hope to have contributed with the two examples.
Thank you very much. I can already draw some similarities of the challenges, especially like the evaluation part seems really challenging for both like British perspective and the Portuguese. And what about French perspective or larger European perspective, Mr. Laprevent?
Yes, thanks. I mean, to go back to one thing that was said before, challenge of greenwashing and risk of basically encouraging agreements that are clearly toxic and suboptimal and collusive. Yes, I see the point personally, but maybe I don't know whether I should say too pessimistic or too optimistic. I don't really see the competition authorities lowering their guard on it. So yes, this might happen, but I doubt it will really be something that competition authorities will turn a blind eye on. A second issue, however, that I would mention, and it goes back to the question of informal guidance, is that this kind of guidance can only take you so far, both in terms of procedure and in terms of substance. In terms of procedure, you still, when you go to the Commission for informal guidance, do not have full, of course, not full, but possibly enough protection against self-incrimination. Obviously, the Commission still has the possibility to launch proceedings. And so you still have a risk that you have a kind of self-censorship from a number of undertakings that would otherwise be interested to get some guidance. On the substantive part, I mean, again, going back to the case I was mentioning before, the safeguards that are designed to this kind of agreement, again, only take you so far, because, you know, if you take this specific example, which was about joint purchasing, but you can extrapolate it to other kinds of agreement, to which point does at some point joint purchasing go as far as becoming biopower that ultimately is going to actually depress the suppliers' incentives to innovate? That's a question. It goes back to the point that, you know, these are complex assessments that I think has not been fully solved. Another question, especially in the context of that we have, I think, not discussed so far, but I think that is important in a number of these sustainability initiatives, is the current trade context, which is that, you know, to which, and behind trade you have resilience, industrial policy, and so on and so forth. To which extent, by essentially fostering sustainability, are you actually going to maybe hamper European players and maybe unwillingly push other players who will provide you, maybe if you only look at the price element, will provide you the required equipment at a great price, but obviously in conditions that will basically destroy your industrial base and make it, at least in Europe, much less resilient. The last problem that I see, and that I think has been alluded to here and there, is we've talked about incorporating sustainability into competition policies. What about incorporating and taking into account competition in a number of sustainability initiatives and regulations? Obviously, the EU again is at the forefront of these kinds of regulations. Has been with the Green Deal. If you take a number of these regulations, I mean, I'll take only one example, which is the deforestation regulation. When you look at the detail of some of the prescriptions of these kinds of regulation, you could also see some requirements to provide, for instance, extremely detailed information, in this case on the origin of the wood that is imported or placed on the market, which themselves actually can become barriers to entry or very large fixed costs that have an impact on competition. I'm not saying that this is necessarily bad in itself, but nevertheless, if you take this, if you take even, for instance, the carbon, the CBAM, border adjustment mechanism, which is aimed at leveling the playing field, these kinds of regulations or initiatives also have an impact on compliance costs and therefore on the conditions of competition. And that, I think, is an issue that also needs to be looked at, in a sense of basically looking at what are the mechanisms that foster and that allow sustainability regulations to be effective, but sometimes maintaining competition is also a very effective way of reaching the goals of sustainability.
Thank you very much, Mr. Lapreva, for highlighting these issues, especially the mutual acceptance of competition policy and sustainability, and not sacrificing one for another, and not doing the other way around. And due to time concerns, I would like to proceed our panelists to their final remarks, where they can highlight the most important takeaways. And also I would would like them to highlight also their perspective, whether this persistence of sustainability and adapting the competition policy to sustainability is the right path forward. Thank you. 2 or 3 minutes.
Thank you. I think it's been mentioned by the panel already. Why should it be sustainability and not other things? And I can tell you already as a private practitioner, we've looked at arrangements that don't quite fit into the environment and have looked for ways of getting it into there, because we do have clients who want informal guidance. Yes, there's still a risk, but it does show communication with the authorities. And certainly in the UK, the participants do feel comfort that the authorities have actually come up with a decision, even though it's informal, and it doesn't stop them changing their mind. But in practice, we haven't seen them doing that. So I think that's important. Also mentioned, regulation is very important in this, and we saw this with the supermarkets case. But the thing about regulation, it does take government time. So we're talking about resources being used anyway. So I think informal guidance, regulation, and also talking to the government on policy are all important. And we've got to have a balance. We've got to look at how it's working. We need to have a mechanism in place for looking back to see the effect of all these different policies. And so really it's a question of balance and getting the right approach to sustainability and not giving it too high a precedence over other types of issues.
Thank you very much, Ms. Mora.
Well, yeah, very short takeaway, promise. So in the end, I would say that sustainability improvements can still and should still emerge primarily through market competition, not through, so this meaning that companies should compete, should bring innovation, should invest as well. And so the cooperations, when needed, should be justified in an adequate, necessary and proportional way. And for that, guidelines, best practices, stating where companies can have exemptions or can have safeguards are very important to bring legal certainty. And for that, it's very important to have market shares, thresholds, etc. But the main message is that, and I just would like to highlight a case that was a case, the ACM in 2015 analyzed the Chicken of Tomorrow case. It's a very well-known case in this sustainability issue. And the ACM said, you know, the agreement seems to be illicit, seems to violate, seems not to be indispensable, and you don't have this comfort letter. And in 2020, then the ACM conducted this follow-up market study to see what happened. And it discovered that sustainability improvements still occurred in the market. And in the case, many supermarkets independently introduced their own higher welfare chicken products and sustainability labels. So competition is an ally of sustainability. Competition can promote safe and secure agreements when needed, e.g. to eliminate first mover disadvantage. But companies should be alerted that NCAs will not hesitate to go against and to issue cartel decisions in case companies need or intend to disguise cartels as pro-environmental cartels.
Thank you very much. Can we go to France virtually?
Yes, maybe 3 points, 3 ideas. The first one, this is more the idea of a private practitioner, but you know, in the practice of advising clients, possibly also authorities, you I would really recommend developing a kind of competition compliance sustainability toolkit, yeah, which is basically taking all the reasonings that we have been discussing in a kind of systematic way to assess an agreement or even a public policy. So looking at what is the objective, the sustainability objective, explain why the counterfactual would be bad, why unilateral action as opposed to cooperation, if we are talking about an agreement, is insufficient. Map out basically the impact on various parameters of competition, and then possibly efficiencies or a debate on the equivalent of 101.3. And that's my second point, which is efficiencies, I think, also play a major role. It's clear that if you're talking about, for instance, mergers, the current efficiencies framework, at least in the EU, is not fit for purpose, especially if we are talking about out-of-market efficiencies. Hopefully, it will be revised very soon in that direction. But after all, the whole point of competition policy is to promote efficiency, and obviously, looking at sustainability goals through the angle of efficiencies is a very powerful solution. Last point, it's something we've not discussed yet. We've talked about regulation, not so much about taxation and competition. I will talk about the opposite of taxation, which is subsidization. It's a major element in a lot of economies developing and developed. It's also part of and parcel of, at least in the EU, of competition policies. And there are fascinating interactions between sustainability and, for instance, state aid control, maybe tomorrow foreign subsidies control. You have an old case law, which is called Iannelli and Meroni, which basically says essentially that the Commission cannot clear aid that is otherwise incompatible with other elements of EU legislation, and that arguably includes sustainability or sustainability legislation. And there are a few cases where this was invoked. I think that it's another example precisely of the interaction between a very important part of public policy, which is just the way governments spend their money, and sustainability. And behind this, you have also a competitive reasoning.
Thank you very much, Mr. Laprevot. So, thanks to all of the excellent panelists of ours for making this extremely interesting discussion happen. And one takeaway that's definitely we can make, that competition and sustainability aren't already separate conversations. They are part of the same policy dialogue. And on this optimistic note, we will close today's session due to time concerns. We apologize our audience, not for allocating some time for questions, but you can always find our panelists and the moderators in the coffee breaks, etc., and ask your interesting and insightful questions. Thank you very much for active listening. Thanks.
Thank you.